Okay, good afternoon, everybody, and welcome to our weekly Facebook Live presentation. We do it every Thursday afternoon at 2 p.m. I'm Jeff Jenkins, and this is Eric Clayman. We're the partners at Jenkins and Clayman, one of New Jersey's, we like to think, premier bankruptcy law firms. And today we're going to be talking about a very interesting and important subject, and that's student loans. Student loans have become a real issue in this country and are frankly quite problematic. Actually, right now, there's more than $1.5 trillion owed on student loans, which approaches the amount owed on residential mortgages. I mean, it's huge. And unfortunately, a lot of that money is owed not only by the students, but also by their parents, who the lender got to co-sign on the loans. And just to give you an idea what a trillion is, okay? If you had to figure out how many days a million seconds took, you would discover it was 18 days. Okay. If you had to look at how much time a billion seconds would take, that would be 32 years. So the next answer is easy. So a trillion seconds takes 32,000 years. This is a lot of money, you know?
Oh, it's 1.5 trillion.
Yeah.
So it's 32.
Well, I'm talking about, you know.
Well, it's 32,000 years plus another, counting by one, two, three. It would take you
48,000 years.
48,000 years. That's a long time.
Yeah, that's right. And so Eric's going to talk about some basic things about student loans, I think, and the bankruptcy code.
Right.
We always try to sneak that in since we're bankruptcy attorneys. And then we're going to go over what the history of student loans and bankruptcy and where we are right now, and talk about what judges are doing right now. And then also we're going to speak a little bit about where we think the new administration might take us with student loans, the Biden-Harris administration, or Harris-Biden. I guess it depends who you're talking to and what day it is. So, Eric.
There are two concepts that we talk about a lot, Jeff and I, during these presentations. Advantages to file bankruptcy, and clients get two concepts that they have to understand, because that's really why you're filing bankruptcy. Number one is the automatic stay, and number two is discharge. And I want to define them again so that when Jeff and I are talking about student loans, you understand what a bankruptcy can do to help you. The moment you file bankruptcy, you're protected by the automatic stay, which will stay or stop all collection actions, not only foreclosures, evictions, and wage garnishments, car repossessions, but also any collection actions by student loan creditors. We've had clients who've had their tax returns taken year after year by the student loan creditor, but that'll be stopped. Student loans are subject to the automatic stay provisions of the bankruptcy code. Now, the second concept is discharge, and that's what we're going to be talking a lot today. Right now, as the bankruptcy code is written, student loans, unless there's an undue hardship, student loans are not dischargeable. Discharge means that after you finish your bankruptcy case, you don't owe the creditor any more money. Most debts are dischargeable: credit cards, medical bills, and the like, personal loans, payday loans, car deficiencies after they've been repossessed. That's how we help people, by discharging that debt. But if we go to the other extreme, we have like criminal fines or child support that are given really special treatment. They're non-dischargeable in a bankruptcy, and the student loans lean towards them. So when Jeff and I talk about the history of this and how it can be dischargeable or not dischargeable, it's important to understand the difference and what that means. It's a big difference. Now, student loans, towards the end of our presentation, we're also going to talk about what Biden is thinking about doing. And part of that is what's called forgiveness outside of bankruptcy, just writing off a debt and forgiveness. And one thing you have to remember is when a debt is discharged in bankruptcy, there's no tax consequence. And let me give you an example of the opposite so you know what I'm talking about. if Jeff loans to me $10,000 and I don't pay it back, I move and I just don't pay it back, it is income to me because I have received $10,000. Jeff writes it off as an uncollectible debt. I am to pay income tax on that.
So forgiveness of debt equals realization of income to the IRS. And that's important to remember with anything, any type of loan where you get
right, and we see that
someone,
and we see that with second mortgages sometimes,
or when you make a deal with a credit card company.
right? And this is all income that's taxable. So we have to be careful about forgiveness of debt. When Congress wrote the bankruptcy code, it understood the Internal Revenue Code as well. And it decided that if people could discharge debts in a bankruptcy case, and it would be taxable, it would defeat the purpose of the bankruptcy. So if Jeff loans me that same $10,000 and I have the same conduct, I don't pay him back because I can't, and I file bankruptcy, it is not income to me. And that's an important distinction, discharging a debt in bankruptcy versus forgiveness of debt, which we're hearing about that the Biden candidacy, Biden presidency with Elizabeth and Bernie Sanders, and that's what they're floating that trial balloon about that idea. All right, so now that we have the concepts down, there's an automatic stay. Debts can or can't be discharged at student loan, depending on the circumstances. And a discharged debt is not a taxable event. Jeff, let's roll our sleeves up and get more into student loan situation, okay? Your sleeves are already rolled up. Good.
Okay. Bankruptcy over the years has treated student loans differently from time to time. And we started out, and as I remember when we started doing this stuff 35 years ago, you could get rid of student loans in a Chapter 13, but not in a Chapter 7. And then they decided that the student loans had to be at least 5 years old to get rid of them. And eventually in 1998, the bankruptcy code was changed, and the changes made student loans non-dischargeable unless repayment would be an undue hardship. And an undue hardship, the court was not defined in the bankruptcy code. The judges came up with several tests that were kind of widely accepted for what an undue hardship is. And it was talk about undue hardship. It was a hard test. I mean, they just, you almost had to be a paraplegic or something to get out of paying student loans.
There were some horrific stories, Jeff. Some of the cases, you read the facts, but most of the judges, when they write their opinions, they set forth the facts. You read these facts and you say, well, this is a winner. This debt's going to be discharged.
Yeah.
And you start reading it. Well, it's possible that he'll grow new legs and grow new arms and be able to.
Yes, it was really horrendous. And just to go through the 3 parts of the most common tests that the courts use, they look at the borrowers can't maintain a minimal standard of living and repay the student loans. That's number 1. Number 2, that situation would continue to exist. In other words, it wasn't ephemeral. It wasn't going to be gone in 6 months. And third, that the person made a good faith effort to pay the loan back. So all 3 of those things had to be present, and they turned it into a really tough test. Now, in the last 5 years, we've seen a lot of judges, bankruptcy judges in the United States, being more lenient. And even if they say they're using one of these tests, like the one I just mentioned is the Bruner test, they are finding things about their case that are factually different that allow them, they feel, to not use that test and to make the student loans completely or partially dischargeable. So
Jeff, let's take a second because that's a great concept. Mm-hmm. It used to be after 1998, we thought it was an all or nothing the way the bankruptcy code was written.
Exactly, and that's the way the courts treat it.
But now there is something called partial discharge, isn't there?
Yeah, a lot of the judges, they've done all kinds of things lately. And I think in an effort, they realize what the problem is with student loans. And they're trying to do something to help the debtor, because the purpose of bankruptcy is to get a fresh start. Now, how do you get a fresh start if you emerge on the other side of bankruptcy with $300,000 in student loans? So they've in some cases, eliminated a lot of the loan or some of the loan. You have to repay the rest. Maybe they've taken away the interest, all kinds of things. So let me go through just a couple of cases real quick. And anytime I go to a seminar and I hear the speaker say, okay, we're going to go through a couple of cases, I got to like kind of slap myself, so I can stay awake. But this will be real quick. So recently in the Southern District of New York, a bankruptcy judge discharged $221,000 in student loans because while the judge, I think it was a she, felt that the borrower couldn't maintain a minimal standard of living if he had to repay the loans, that she felt that that situation may not continue to exist, but it was going to exist long enough that there was no way that he was going to be able to reasonably pay back the loans. There was another case in the Northern District of Iowa in 2019 where the bankruptcy judge allowed $230,000 of student loans to be discharged. And I'm just going through these things to show you that there's some movement with the bankruptcy judge's opinions about student loans. And so there's hope. If we have somebody come in and things might not have to be as bleak as that old test necessarily to get the judges to agree to discharge some or all of the student loan. Another couple of cases in 2018, same court, Northern District of Iowa, and that was a female judge, not that that makes any difference, but she discharged.
Her husband's a corn farmer, by the way.
Or potatoes, Eric. Iowa.
Iowa.
Oh, Iowa, you're right.
Could be potatoes.
Anyway, husband and wife had $154,000 worth of student loans, and the judge felt that they could repay $23,000 of it, and the rest of it was discharged.
And that is a relatively new development, and it's promising. And do we think that might happen in New Jersey? Yes, that's one of the things that we think might happen.
We hope. Our bankruptcy judges have said, please give us some student loan cases. Like they're chomping at the bit to do something with student loan cases. The last one I'm going to talk about in the Southern District of California in 2020, $430,000 of student loans were discharged, and the debtor only had to pay $8,000 back above the $430,000, and he had 17 years to do that. So it just gives you, I'm just trying to give you a sense of some of the things that the judges are doing now with student loans.
But of course, these are merely examples.
Right.
And you should not rely on these examples
No.
for your own particular situation.
Yeah.
And we do not mean to give you an unrealistic expectation.
Yeah, that's very good. Eric, it's up to the judge. And we don't have any real definitive opinions in New Jersey that I'm aware of. I mean, we have those, the tests, the two tests, but the judges are finding ways to do something creative to get rid of student loans if they feel that's the correct result when somebody files a bankruptcy. Okay, now we want to talk about what we think might happen with the Biden administration and what different senators have said. And keep in mind that senators, or a senator might be in favor of doing something with student loans, and he might say, well, I'd support this, I'd support that, I'd support something else. And they're all ways of getting rid of student loans or partially getting rid of them, but they might not be identical propositions. So the Republicans and the Democrats have talked about doing something about the student loan problem. And Elizabeth Warren, for example, supports making student loans dischargeable in a bankruptcy. I think that's what she would like to see, is the bankruptcy code changed and allowing bankruptcy judges to forgive student loans with a regular discharge, just like medical bills and credit cards are discharged.
Right. That would be the most aggressive approach that we've seen, although most aggressive that we've seen from the bankruptcy perspective. The advantage of Elizabeth Warren's plan is that we already have an infrastructure of judges and trustees who can review the cases to see if there is any abuse happening and things like that. In other words, when people file bankruptcy, they file their bankruptcy petition with our assistants and they answer all the questions truthfully and submit a list of assets and a list of income. And if they qualify, they get a discharge. So you already have that infrastructure rather than other methods to partially discharge or forgive student loans. And that's what we were going to talk about as well, is some of the forgiveness that Joe Biden mentioned, actually, while he was still running for office, I think, was the $10,000 student loan forgiveness as part of the CARES Act, which just wasn't enacted. I'm throwing you off your course, so you can keep talking if you want, but I can, whatever.
All right. Chuck Schumer, Senator Chuck Schumer and Elizabeth Warren have both said they'd be willing to do something that would forgive $50,000 of student loans per borrower with no tax liability. They were smart enough to put that little caveat in there. Eric talked about Joe Biden and the $10,000 as part of another CARES Act or legislation.
And Jeff, we do think what we're reading, let's talk about that for a second, because many of our episodes have dealt with the CARES Act. Mm-hmm. I wouldn't be surprised this last time they gave $600. It seems as if the Democrats are inclined to add $1,400 to it, to make it $2,000.
Yes, and they say as much, and Joe Biden has recently said as much, and Nancy Pelosi certainly did. She was willing to do that before this current legislation was passed.
So if we see that, this would provide an opportunity for Biden to stick in there a student loan provision.
Absolutely.
Whether it's $10,000 or whether it's $50,000, or we have seen, and you've talked about this with specificity, each of the two earlier CARES Act money for people included in the law amendments to the bankruptcy code. Mm-hmm. So it is possible that there could actually be an amendment to the bankruptcy code as part of this CARES Act to incorporate different language for a student loan. Right. So it's very, very important if you are having student loan repayment difficulties, and you can type into Google student loan crisis, and you will read articles and articles. People are calling it a crisis. If you're a victim of this crisis, give us a call. If not today, tomorrow, call us, and we can help you manage through this by explaining how the law can work for you.
Mm-hmm. Absolutely. Yeah. And I have read as recently as this morning that Joe Biden is very interested in having another iteration of the coronavirus legislation and throwing around numbers. Here we go with a million, billion, trillion. It's something close to $1 trillion. And part of that, he says he would like to see something done with student loans, even if it's just a one-time thing and discharging so much. But one thing that he did want to do is right now, of course, you've got like a payment moratorium on student loans, and there's no interest charged, there's no penalties or anything like that. And that moratorium is supposed to end at the end of January. Joe Biden wants to push it back to the end of September of this year, 2021. So if we see some new legislation, I would expect that to be in there too. Joe Biden has also said he's been in favor of forgiving $10,000 a year per borrower if you have a national or community service job. And since if we're talking about that, let's also mention that for a long time there have been certain federal programs where if you they have different ones for different periods of time, 10 years, 15, 20, 25 years, you can pay what you can afford on your student loan if you can get involved in one of those programs, and what you can afford may be zero. And at the end of the period, whichever one it is, the balance is forgiven, but it's taxed, like we talked about before. And there's also, of course, certain jobs that you can take according to federal law, where if you work, like at a legal clinic or something for 10 years, you can have your student loans forgiven, and you don't have to pay them while you're in that particular job.
Let's talk about some ways we've helped clients over the years. I remember this woman that you helped that had a lot of student loan debt, and some credit card debt. And she was optimistic that she had a job, but she would be able to get a better job. And we brainstormed, and you came up with a very creative solution.
Yeah, we've done trying to help people that have student loans. We've done things that are short of filing a complaint and trying to get the whole thing discharged. So we have had some clients that had student loans and they just could not make the payments. There was no way they could. They didn't have a good enough job. And so we filed a bankruptcy, Chapter 13, had it last for 5 years, had them pay back what they could handle for all their creditors. But the main reason we would do that type of bankruptcy would be to give our client time to get a better job and have them be in a better position to pay what the student loan people wanted them to pay. We've done that several times and it's worked out very well.
Right, it's a couple of really big advantages. Number one, we talked about the fact that student loan people take tax refunds. Well, not after you file bankruptcy. So if we can do a Chapter 13 that's 5 years, you're completely protected. There's no phone calls. It's a big weight off your back, mentally as well as financially. You have to do something with your credit cards anyway. So it's a payment plan, not to pay them back in full, but based on your present income, again, over 5 years. So you're protected mentally and financially from the credit cards and student loan organizations. And then hopefully at the end of 5 years, even though you still owe the money, who knows, there could be a different president in 5 years, a different Congress, the laws could change. You can get married. What's that expression you like about 5 minutes versus?
Right, you can make more money in 5 minutes than you can in a lifetime.
You can get married, you can get a better job. There's all sorts of things that can change in 5 years. But during that 5-year period, you're making a realistic payment to a trustee for the benefit of creditors. And just this weight is off your shoulders. It really does work.
Yeah. One thing I wanted to mention also, Eric, is if we do a Chapter 13 for somebody, not only are they protected from their creditors, but if there's a co-signer, and there are in so many of these student loans, parents, grandparents get dragged in as co-signers. Co-signers in a Chapter 13 for a consumer debt are protected just like the person filing the bankruptcy. And the majority of the courts, when they've looked at is a student loan a consumer debt or is it not, have found that they feel it is a consumer debt. They look at different things, and it's complicated, but most of them decide that it is a consumer debt. So therefore, that co-debtor stay provision in Chapter 13 would apply. And by doing a Chapter 13, then the person is keeping the student loan creditors away from their family who are co-signers.
That is an important concept.
Yep, absolutely.
So it's very, very helpful. And again, we can have the Chapter 13s last up to 5 years. So that's a lot of protection for people. And we get really positive feedback. You can do this? You can help us like that? And it's very rewarding. Jeff, I think this has been a nice little lesson in student loans.
Yeah, I hope so. I think it gave you a flavor for what's going on right now. I hope.
And if you have any further questions, you can just call us. It'll probably be Robert answering the phones today at 856-546-9696. But I'll forward your call to Jeff or me or possibly Stephanie or Rondi and the 4 lawyers working here, and we're all here ready to help you.
Yeah, absolutely. So why don't we sign off, and thanks to all our viewers for watching us today. We appreciate it. And we'll see you next week, same time, same place.
We're going to do this again next week?
Why not?
All right.
There's nothing special going on next week. So next Thursday at 2 o'clock. And until then, stay safe and God bless.